Good day, it's Chris Bacon, the brain injured guy. Hopefully, this is finding everybody well. Here to do a new installment on Bill C-45, an overview. This is actually Bill C-45 from 2003. So what they do is they actually recycle the numbers. So if you go and search this under Bill C-45, it'll come up something about, I think it's defense or something now. Anyway, a little bit too much light there. Okay. So anyway, yeah. So Bill C-45 back in that time had to do with occupational health and safety, amendments to the criminal code with regard to occupational health and safety, and it was initiated in 2003. I think it was a private member's bill, and it ended up becoming law. It was brought into law March 31st, 2004 in full force and effect. So anything that comes after March 31st, 2004 would apply. And again, this is stuff that people don't tell you, especially the government. So this is why this is for educational purposes. Again, I'm not going to try and embellish anything at all or add anything to it. I'm going to try and read it just like I did for the my handbook for guide for parliamentarians from the UN with regard to the Committee on the Rights of Persons with Disabilities and the protocol and optional protocol for persons with disabilities under the UN. That's also available on my channel. Feel free. Anyway, this is, again, Bill C-45 at that time. I'm reading from www.ccoch&S.ca/OSH/LEGISL/Bill C45.html. And what that is that's a Government of Canada website for the Canadian Centre for Occupational Health and Safety, or CCoHS. It's an OSH Answers Fact Sheets page of their website. Now, what that is, it says easy to read question and answer fact sheets covering a wide range of workplace health and safety topics from hazards to diseases to ergonomics to workplace promotion. And there's a link to more about. I'm sure this is probably a really good resource for finding out information and informing yourself, because nobody else is going to tell you unless you look them in the eye and ask them a direct question. Anybody who's dealt with government, well, you know that already, don't you? Anyway, so that's why we're here with education. And again, I encourage all people to self-educate. I certainly got an education over the last 13 years as to exactly how this government and its basic affiliations operate this, what I deem a criminal system from my experience. I'm sure that there's a lot, like, again, not every system is perfect, but this is one part of it that I would like to see eradicated. And it is definitely worth a discussion. And especially under the context of finding out that, yes, this is the smoking gun. This is why the government has been making me into the most dangerous person in Canada because of my disability. I'm a brain injured person. And I record digitally my interactions with persons, especially government and doctors and that. But it wasn't for any facetious reason initially. It's just to participate in my own life. The fact that it also serves as a digitally recorded record of real-time interactions with these people in their natural habitat and environment and their own zone of safety, or zone of safety, where they feel that they are so protected that, well, you can hear for yourself when we start releasing them. And you'll see, well, in your own experiences, you already know that there's a question of who they're there to protect. Well, the answers are contained on my 13 years of tapes between doctors and the medical system and the legal system and the workplace safety and insurance system, which I like to affectionately call the Workplace Slavery and Interference Board, as has been my experience, personal experience. And after 12 years, they say that after 10 years, you're an expert. So anybody would like to submit any questions? I'm not a legal person, but I certainly have a lot of experience with how they do things at the WS&IB. And if you would like to ask a specific question, I might be able to point you in the right direction. So feel free, if that's going to be what it takes to get people involved in this action. We are here to help each other. And if we don't start helping each other, well, nobody's helping us. So we need to show them how we do it. And that can go across the board for everything. So I hope, as I'd like to stress in these videos, I hope that people will get involved, that people will see that this is the most important thing, that it's not about which political party, it's not about whether or not there's waiting lists or not. It's about the rule of law and how out of control the rule of law has gotten, to the point where those who claim to have authority do not know the difference between power and authority, because authority is when you are given the will of the people and the people are behind you, and that is through honest representation. This thing that's going on, where everything is misrepresented and everything is just smoke and mirrors, everybody knows where we're standing. If you're honest with yourself, there's something wrong. Well, this is it. It's the rule of law. You know how they said it's what was it, that political saying about it's the taxes, stupid, or something like that. No, it's not. It's the rule of law and the way that the disparity is. And the fact that you think just because you have the power, that gives you the authority. No, you may have the power, but you do not have the authority without integrity. And if there's no integrity, that's not authority. That is feigned authority and bully tactics through power. And if you don't know the difference, then you certainly shouldn't be sitting in a House of Parliament or government, especially when you claim to be representing all your constituents and all the people. Because, again, you like to point the fingers and say, it's not my responsibility. Well, I beg to differ. And I think everybody else should too. And I think we should start getting along the same line. It is all of our responsibility. If all of us are not individually carrying out our duties, which is respect under the law, and given my experience, I still respect the law. I have to, because, well, it's my morality, right and wrong. It's the same thing. There's no difference. It's not 50 shades of gray. It's black and white. And unless you want to make excuses. So, Justice Minister and Justin Trudeau and all you other people who like to point the fingers, brain-injured guy here tried to point you in the right direction. It's all of our responsibility. Time to step up to the plate, and especially in light of what I'm about to read. So again, Bill C-45 at that time, 2003. It's something else today if you look it up, because they recycle the numbers. So it says here, what is Bill C-45 as of this point? Bill C-45 is federal legislation that amended the Canadian Criminal Code and became law on March 31st, 2004. The bill established new legal duties for workplace health and safety and imposed serious penalties for violations that result in injuries or death. The bill provided new rules for attributing criminal liability to organizations, including corporations, the representatives, and those who direct the work of others. It created new sections of the Criminal Code. Bill C-45 added Section 217.1 to the Criminal Code, which reads, quote, 217.1, everyone who undertakes or has the authority to direct how another person does work or performs a task is under a legal duty to take reasonable steps to prevent bodily harm to that person or any other person arising from that work or task, end quote. Bill C-45 also added sections 22.1 and 22.2 to the Criminal Code, imposing criminal liability on organizations and its representatives for negligence under 22.1 and other offenses under 22.2. Why was Bill C-45 section 217.1 in the Criminal Code created? Bill C-45, also known as the Westray Bill, was created as a result of the 1992 Westray coal mining disaster in Nova Scotia, where 26 miners were killed after methane gas ignited, causing an explosion. Despite serious safety concerns raised by employees, union officials, and government inspectors at the time, the company instituted few changes. Eventually, the disaster occurred. After the incident, the police and provincial government failed to secure a conviction against the company or 3 of its managers. A Royal Commission of Inquiry was established to investigate the disaster. In 1998, the Royal Commission made 74 recommendations. The findings of this commission, in particular Recommendation 73, were the movement that led to Bill C-45. What are the main provisions of Bill C-45, Section 217.1 in the Criminal Code? Bill C-45, Section 217.1 in the Criminal Code, created rules for establishing criminal liability to organizations for the acts of the representatives. It establishes a legal duty for all persons, quote, directing the work of others, end quote, to take reasonable steps to ensure the safety of workers and the public. Sets out the factors that courts must consider when sentencing an organization, and provides optional conditions of probation that a court may impose on an organization. Who do these provisions of the Criminal Code affect? These provisions of the Criminal Code affect all organizations and individuals who direct the work of others anywhere in Canada. These organizations include federal, provincial, and municipal governments, corporations, private companies, charities, and non-governmental organizations. Who is responsible for enforcing this criminal code? Police and Crown attorneys enforce Bill C-45. The police and Crown are responsible for investigating serious accidents and will determine whether any charges should be laid under the Canadian Criminal Code. Criminal Code is a very different set of rules and should not be confused with regular occupational health and safety laws, OccH&S, and how they are enforced. Who is responsible for enforcing occupational health and safety laws? Depending on your jurisdiction, the Ministry or Department of Labor or Workers' Compensation Board enforce OccH&S laws, also known as the Workplace Safety and Insurance Board in Ontario. Across Canada, each province, territory, and the federal government are responsible for enforcing their own individual set of occupational health and safety laws. Each jurisdiction employs inspectors who visit workplaces to ensure companies are complying with their OccH&S rules. In the unfortunate event of a serious accident, these inspectors conduct an investigation and determine if a charge should be laid under the appropriate sections of the OccH&S Act or regulation. An accused individual or company may then need to appear in court where a fine or other penalty could be imposed if they are convicted. The police are not normally involved in this process. So it doesn't say they're not ever, it just says they're not normally. Does Bill C-45, Section 217.1 in the Criminal Code impact on other legislation? No. Bill C-45 is a separate piece of legislation that applies to the Canadian Criminal Code only. It does not intrude upon or override other existing federal, provincial, or territorial occupational health and safety statutes and regulations. In the event of a conviction, however, Bill C-45 does not, In the event of a conviction, however, Bill C-45 does require the courts to look at any penalties imposed by other jurisdictions in determining a sentence. Can a company be charged under Provincial OccH&S Act and the Criminal Code at the same time? Yes, it is possible. It is common practice for both police and health and safety inspectors to both investigate a serious workplace accident. In most cases, the police and provincial authorities would work together to decide which charges should be made. While it is unlikely that 2 sets of charges would be made, technically speaking, charges can be laid under both the Criminal Code by the police and the Occupational Health and Safety Act, or regulations by provincial authorities. This situation has occurred in the Millennium Crane Rentals case from Sault Ste. Marie, Ontario. What types of offenses will be targeted? To date, there are 8 cases where individuals were charged under the new provisions in the Criminal Code. See below for a brief summary of the charges. Note, at the time the law was being discussed in Parliament, the government commented on its intentions for the bill, stating that, quote, the criminal law must be reserved for the most serious offenses, those that involve grave moral faults, ... The government does not intend to use the federal criminal law power to supplant or interfere with the provincial regulatory role in workplace health and safety, end quote. Has anyone been charged? Yes. To date, there have been 8 cases where charges have been laid. Most of these cases did see other charges and fines issued using the occupational health and safety legislation of the jurisdiction where the incident took place. On February 11, 2010, Sault Ste. Marie Police charged the owner of Millennium Crane Rentals and the crane operator with criminal negligence causing death after a municipal worker was killed while working in an excavation hole. The accident occurred on April 16, 2009 at an excavation site where the sewage work was being performed. Where sewage work was being performed. There's no doubt there. The crane toppled and fell into the hole, killing the worker. In March 2011, the Crown announced that it had dropped the charges of criminal negligence causing death because there was no reasonable prospect of conviction based on the evidence. In July 2013, Millennium Crane Rental was, however, found guilty of failing to ensure that the crane was maintained in a condition that would not endanger a worker and fined $70,000 for a violation of the Ontario Occupational Health and Safety Act. On December 24, 2009, 4 workers were killed and 1 was seriously injured at a Toronto construction site when the swing stage scaffolding they were on collapsed. Metron Construction and 3 corporate officers were charged with criminal negligence and fined $200,000 plus a victim surcharge of $30,000. Metron's owner was personally fined $90,000 plus a victim surcharge of $22,500 under the Ontario Occupational Health and Safety Act. A total of 61 charges were laid by the Ministry of Labour. The fine against the company was appealed, and in September 2013, the appeal court tripled the fine against Metron, raising it to $750,000 for criminal negligence. An additional victim surcharge of $112,500 was levied against the company. The appeals court judge found that the original fine of $200,000 was, quote, manifestly unfit, end quote. 1 supervisor named in the case will be on trial in the fall of 2013 for charges of criminal negligence causing death. On March 17, 2008, a paving company, and then quotes, it identifies as Transpave, Transpave, and parentheses, was charged and convicted of criminal negligence and fined $100,000 in the death of an employee plus a $10,000 victim surcharge. On May 17, 2007, Mark Hritchuk, Hritchuk, a service manager at a LaSalle, Quebec auto dealership, was charged with criminal negligence after one of his employees caught on fire while using a makeshift fuel pump that had gone unrepaired and broken for several years. Mr. Doust, a 22-year employee with the company, was engulfed in flames after a spark-ignited fuel which had spilled on him while he attempted to fill the gas tank of a vehicle whose fuel gauge had broken and needed repairing. The employee survived but received third-degree burns to 35% of his body. The case was brought before the Court of Inquiry on March 10, 2009. The case went to court on March 2012. Mr. Hritchuk pleaded guilty of unlawfully causing bodily harm. On October 13, 2006, a train struck a maintenance vehicle, killing 1 worker and injuring 3 others. 2 employees of Quebec Cartier were charged with criminal negligence causing death and 3 counts of criminal negligence causing bodily harm. The corporation was not charged. On November 29, 2010, a Quebec court acquitted both men on all counts, finding that the incident was an error due to the company culture of tolerance of unsafe practices and deficient training rather than a wanton act of criminal negligence. It doesn't state whether or not the company was then therefore charged criminally under the same act. You would wonder why they wouldn't if that was the finding of the court. On June 12, 2006, a landscape contractor was crushed to death when the backhoe his employer was driving failed to stop, pinning the employee to a wall. The investigation of the incident found that the 30-year-old backhoe had not received any regular maintenance since the vehicle was purchased, and that no formal inspection had been done in the previous 5 years. Upon further investigation, it was discovered that the vehicle had no braking capacity. In September 2010, the employer was convicted of criminal negligence causing death and was given a 2-year conditional sentence to be served in the community. On March 22, 2006, BC Ferries vessel Queen of the North sank after going off course and running aground, killing 2 passengers. The ferry navigation officer was charged with 2 counts of criminal negligence causing death. The officer was reported to have been distracted by a personal interaction he was having with another person and did not realize that the vessel was off course. On June 24, 2013, he was sentenced to 4 years in prison and banned from operating a vessel for 10 years. An appeal has been filed. On April 19, 2004, near the city of Newmarket, Ontario, a worker was killed after the ground around him collapsed while digging a ditch at a residential construction site. The construction site supervisor was charged under Section 217.1 of the Criminal Code and with one count of criminal negligence causing death. In March 2005, the charges of criminal negligence against the site supervisor were dropped in an apparent plea bargain, which saw the supervisor agree to 3 of 8 charges under the Ontario Occupational Health and Safety Act and fined $50,000 with a 25% victim surcharge. I need a little bit of a break. I'll be right back. Okay, how can I ensure a safe workplace and limit my liability? Employers can limit their liability and reduce the chances of being charged under the provisions of the Criminal Code by implementing an effective workplace health and safety program. You will want to know what your legal obligations are under occupational health and safety laws and standards, what hazards exist in your workplace, how to effectively reduce or eliminate them. You will also want to ensure employees are aware of the company's health and safety program, are informed of any risks, and receive appropriate training and protective equipment. Below are some OccH answer documents that may help. You may also want to consider hiring a health and safety consultant to assist you with this process. There is a section called Responsibilities, which has 4 links underneath it. OccH&S legislation in Canada, Introduction. OccH&S legislation in Canada, Basic Responsibilities. OccH&S legislation in Canada, Internal Responsibility System. OccH&S legislation in Canada, Due Diligence. And then there's a section, Elements of Health and Safety Program. There's 1, 2, 3, 4, 5 links under that. First one is Basic OccH&S Program Elements. Second is Job Hazard Analysis. Third, Risk Assessment. Fourth, Inspection Checklist, General Information. 5 is Guide to Writing an OSH Policy Statement. Then it states, for further information, review our Health and Safety Program section of OSH Answers, and that's another link for health and safety programs. So I will only go, we're not going to get into the whole thing about a health and safety program. Of course, that's something that you should follow up, and this website does have it available. I will go through the responsibility section, though, because I think it's important. It lays the foundation for what we're about to discuss moving forward with this series. And what's necessary, and also points out to the available people exactly what I'm talking about with regard to my personal experience over the last 12 to 13 years. So, under responsibilities, OccH&S legislation in Canada introduction. We clicked on the link and it takes us over to the web page, which is www.ccoanswers/legisl.intro.html. Again, this is Government of Canada website for the Canadian Centre for Occupational Health and Safety, also known as CCoCs. OSH answers fact sheets, which again is easy to read question and answer fact sheets covering a wide range of workplace health and safety topics, from hazards to diseases to ergonomics to workplace promotion. So this is a very good, useful tool for all the worker safety reps that should be working and in place as a legal requirement under the law in every workplace that has under 20 employees. Again, go to the Ministry of Labor website, Occupational Health and Safety Act, which is known as in Ontario, the Ontario Health and Safety Act, which can be found on the e-laws website, and you can see directly what it says and what the requirements are for a worker safety representative and what you are entitled to under that position and what your power is under the law. So an employer cannot, well, they can say no. But if they say no, then a certain situation comes into effect. And again, why they don't teach this in schools, I don't understand. We should have that done right away, that people being able to identify a safe workplace and knowing their rights under the law with regard to every workplace in Ontario and Canada. Well, I mean, we can deal with Ontario, but I'm sure Mr. Trudeau would be really helpful to all the people for educating them and also saving money within the system if everybody's aware of what their rights are and nobody can have the wool pulled over their eyes anymore. That would save a lot of taxpayers' money, would save a lot of time and bogged down backlog in the courts and tribunal systems. We need leadership. Anybody step up. You got Premier Wynne. You pretend to be a leader, in my opinion. Anyway, so here we are, OH&S legislation in Canada, introduction. What occupational health and safety agency covers my workplace? There are 14 jurisdictions in Canada, 1 federal, 10 provincial, and 3 territorial, each having its own occupational health and safety legislation. For most people in Canada, the agency that you would contact is a provincial or territorial agency in the area where you work. There are some exceptions to this. Federal legislation covers employees of the federal government and crown agencies and corporations across Canada. Where can I find out about my duties in Canadian legislation? Occupational Health and Safety, OH&S legislation in Canada, outlines the general rights and responsibilities of the employer, the supervisor, and the worker. Each of the 10 provinces, 3 territories, and federal government has its own OH&S legislation. There is a special right to know legislation that applies to hazardous products. It actually comprises several pieces of legislation collectively called WHMIS. WHMIS is referred to as WHMIS. The Workplace Hazardous Materials Information System. It is a comprehensive plan for providing information on hazardous materials intended for use in workplaces. WHMIS applies in all Canadian workplaces which are covered by occupational health and safety legislation and where WHMIS controlled products are used. Again, WHMIS is WHMIS, which is Workplace Hazardous Materials Information System, acronym. Who is covered under the jurisdiction of the federal government in Canada? The federal health and safety legislation is commonly referred to as Canadian Labour Code Part 2 and regulations. The Canadian Labour Code also applies to employees of companies or sectors that operate across provincial or international borders. These businesses include airports, banks, canals, exploration and development of petroleum on land subject to federal jurisdiction, ferries, tunnels, and bridges, grain elevators licensed by the Canadian Grain Commission, and certain feed mills and feed warehouses, flour mills, and grain seed cleaning plants, highway transport, pipelines, radio and television broadcasting and cable systems, railways, shipping and shipping services, and telephone and telegraph systems. Approximately 10% of the Canadian workforce falls under the OH&S jurisdiction of the federal government. The remaining 90% of Canadian workers fall under the legislation of the province or territory where they work. Who is covered by provincial and territorial jurisdictions? In each province or territory, there is an act, typically called the Occupational Health and Safety Act or something similar, which applies to most workplaces in that region. The act usually applies to all workplaces except private homes where work is done by the owner, occupant, or servants. Generally, it does not apply to farming operations unless made to do so by a specific regulation. The legislation should be consulted to find out who is or is not covered. At the provincial and territorial level, the name of the provincial government the name of the government department responsible for OH&S varies with each jurisdiction. Usually it is called the Ministry or Department of Labor. In some jurisdictions, it is a workers' compensation board or commission that has the responsibility for occupational health and safety. Each provincial or territorial department is responsible for the administration and enforcement of its Occupational and Safety Act and regulations. A list of Canadian government departments with chief responsibility for occupational health and safety is available elsewhere on this site. And actually, where it says Canadian government departments with chief responsibility for occupational health and safety is a link to, obviously, that. That's the end of that web page. Document last updated on July 8th, 2008. So now we move on to the next point, which is OH&S legislation in Canada, basic responsibilities. Pressing that link takes you to www.ccohs.ca/OSH answers /legisponsi.html. That again is a Government of Canada website for the Canadian Centre for Occupational Health and Safety, also known as CCoHS, OSH answers fact sheets, and this is on OH&S legislation in Canada, basic responsibilities. Are there any similarities in OH&S legislation across Canada? Many basic elements, for example, rights and responsibilities of workers, responsibilities of employers, supervisors, etc., are similar in all the jurisdictions across Canada. However, the details of the OH&S legislation and how the laws are enforced vary from one jurisdiction to another. In addition, provisions in the regulations may be mandatory, discretionary, or as directed by the minister. What are the responsibilities of the governments? General responsibilities of governments for occupational health and safety include enforcement of occupational health and safety legislation, workplace inspections, dissemination of information, promotion of training, education, and research, and resolution of OH&S disputes. What are the employees' rights and responsibilities? Employees' responsibilities include the following: responsibility to work in compliance with OH&S acts and regulations, responsibility to use personal protective equipment and clothing as directed by the employer, responsibility to report workplace hazards and dangers, responsibility to work in a manner as required by the employer and to use the prescribed safety equipment. Sorry, I put 2 in there. It actually says responsibility to work in a manner as required by the employer and use the prescribed safety equipment. Employees have the following 3 basic rights: right to refuse unsafe work, right to participate in the workplace health and safety activities through Joint Health and Safety Committee, JHSC, or as a worker health and safety representative. Right to know or the right to be informed about actual and potential dangers in the workplace. I will make a footnote here. In Ontario, the separation is 20 employees or under. You're required under law in every workplace to have a worker health and safety representative. Any employer with over 20 employees is required to have a joint health and safety committee. That was my understanding, and I haven't checked it like yesterday or anything like that, but if you want to find out, go to the appropriate government websites, Ministry of Labor, e-law websites, a very good website. You can look up the Occupational Health and Safety Act for Ontario, which is the first act, even before Workplace Safety and Insurance Act, which binds the Crown and everybody else, including Workplace Safety Insurance Board, hi David Marshall, and the Crown and the government, Ms. Wynne. And you need to review how the law works and make sure that you understand it, because I don't think you understand it. Well, no, actually, I think you understand it very well. You just like to play with it. Anyway, time to get some clarity, eh? I'm sure this case will make a lot of clarity, no matter if it's in the judicial system or in the court of public opinion, because the good thing about being recorded is that I could say what I want, because you want to challenge me, I just press play. And I'll be pressing play anyway. With it well documented, we will get it transcribed so people could hear exactly how you operate on every level. But we already know that. The difference is I've got it documented in real time, in your words and your actions. Self-explanatory, self-demonstrated, and certainly very telling. Again, raising the question, who exactly are you there to protect? A question everybody already knows the answer to. For some reason, I guess the truth hurts certain people. Well, you know, we could enact change. It's one person, one vote, majority rules. basic question is, are we finished with this nonsense? Because if we are, it's time to end it once and for all with severity, with a vote. And let's change the system more once and for all. And we need more than just first past the post. More importantly, we need none of the above as a general consensus, as a general plebiscite, and an option for everybody to have a chance to vote, especially the demographic that doesn't get a ballot to mark unless it's lesser of the three evils as the worst. Again, you're trying to divide the vote, when the real vote should be none of the above, which means, yeah, here's our percentage saying we don't agree with any of you, and anybody claiming a majority, we're not voting for the actual party getting in, but we're definitely demonstrating that we're not satisfied. So if you only take 30% of the vote and you claim that as a majority, well, you're going to be looking at that other 60% or whatever, or 70%, and you're going to be going, hey, what do they say? Because if they're not agreeing with me, then I can't go out there pretending like they do, just because I claim 30% of the vote and claim it as a majority. It would certainly help with policy directive and not running us around, because if 60% are staying home, that says that their vote's registered. They're not buying it. Anyway, that's another tape. So, what are employees' rights and responsibilities? Employees' responsibilities include the following: responsibility to work in compliance with OccH&S acts and regulations. Responsibility to use personal protective equipment and clothing as directed by the employer. Responsibility to report workplace hazards and dangers. Responsibility to work in a manner as required by the employer and use the prescribed safety equipment. Employees have the following three basic rights. Oh, I already did that. Okay, anyway. Right to participate in the... Employees have the following three basic rights: right to refuse unsafe work, right to participate in the workplace health and safety activities through Joint Health and Safety Committee, JHSC, or as a worker health and safety representative. Right to know or the right to be informed about actual and potential dangers in the workplace. What are the manager or supervisor's responsibilities? As a manager or supervisor, he/she must ensure that workers use prescribed protective equipment devices, must advise workers of potential and actual hazards, must take every reasonable precaution in the circumstances for the protection of workers. Managers and supervisors act on behalf of the employer and hence have the responsibility to meet the duties of the employer as specified in the Act. What are the employer's responsibilities? An employer must establish and maintain a joint health and safety committee or cause workers to select at least one health and safety representative. Take every reasonable precaution to ensure the workplace is safe. Train employees about any potential hazards and in how to safely use, handle, store, and dispose of hazardous substances, and how to handle emergencies. Supply personal protective equipment and ensure workers know how to use the equipment safely and properly. Immediately report all critical injuries to the government department responsible for OccH&S. Appoint a competent supervisor who sets the standards for performance and who ensures safe working conditions are always observed. What does the legislation say about forming health and safety committees? Generally, legislation in different jurisdictions across Canada state that health and safety committees or joint health and safety committees must be composed of one-half management and at least one-half labor representatives. Must meet regularly. Some jurisdictions require committee meetings at least once every 3 months, while others require monthly meetings. Must be co-chaired by one management chairperson and one worker chairperson. Sorry, I put the one in there. It actually says, must be co-chaired by one management chairperson and worker chairperson. Employee representatives are elected or selected by workers or their union. More details about these committees are in the Health and Safety Committee section on this site, and Health and Safety Committees is a link. What is the role of Health and Safety Committee? The role of Health and Safety Committees or Joint Health and Safety Committees include act as an advisory body, identify hazards and obtain information about them, recommend corrective actions, assist in resolving work refusal cases, participate in accident investigations and workplace inspections, make recommendations to the management regarding actions required to resolve health and safety concerns. What happens when there is a refusal for unsafe work? An employee can refuse work if he or she believes that the situation is unsafe to either himself or herself or his or her coworkers. When a worker believes that a work refusal should be initiated, then the employee must report to his or her supervisor that he or she is refusing to work and state why he or she believes the situation is unsafe. The employee, supervisor, and a joint health and safety committee member or employee representative will investigate. The employee returns to work if the problem is resolved with mutual agreement. If the problem is not resolved, a government health and safety inspector is called. An inspector investigates and gives decision in writing. How is legislation enforced? The legislation holds employers responsible to protect employee health and safety. Enforcement is carried out by inspectors from the government department responsible for health and safety in each jurisdiction. In some serious cases, charges may also be laid by police or crown attorneys under Section 217.1 of the Canada Criminal Code, also known as Bill C-45. This section imposes a legal duty on employers and those who direct work to take reasonable measures to protect employees and public safety. If this duty is, quote, wantonly, end quote, or recklessly disregarded and bodily harm or death results, an organization or individual could be charged with criminal negligence. Where can I get more information about responsibilities? If you have specific concerns about what regulations require employers and workers to do, you should consult local authorities in your jurisdiction. This is especially true if your questions deal with the content, interpretation, compliance, and enforcement of the legislation and how it applies in your own workplace situation. We have provided referrals in this section on OccH&S agencies responsible for occupational health and safety. Local offices are usually listed in telephone directory blue pages or under separate federal and provincial government headings and other telephone directories. This is the end of the page. In that last paragraph where it says OccH&S agencies, the word agencies is a link to those agencies, I would imagine. Document was last updated on June 17, 2008. And that ends that page. Then we go to the third tab, which is OccH&S legislation in Canada, internal responsibility system. And that, making that link brings you to www.ccohs.ca/OSH answers /legisl/IRS.html, which is again Government of Canada website for the Canadian Centre for Occupational Health and Safety, also known as CCoHS. OSH answers fact sheets on OccH&S legislation in Canada internal responsibility system. I will have to take a short break and I will be right back with that. Thank you. Okay, what is the internal responsibility system? The internal responsibility system puts in place an employee-employer partnership in ensuring a safe and disease-free workplace. The Health and Safety Committee is a joint forum for employers and employees working together to improve workplace health and safety. How does the internal responsibility system work? The internal responsibility system is the underlying philosophy of the occupational health and safety legislation in all Canadian jurisdictions. Its foundation is that everyone in the workplace, both employees and employers, is responsible for his or her own safety and for the safety of co-workers. Acts and regulations do not always impose or prescribe the specific steps to take for compliance. Instead, it holds employers responsible for determining such steps to ensure health and safety of all employees. Internal responsibility system does the following: establishes responsibility sharing systems, promotes safety culture, promotes best practice, helps develop self-reliance, ensures compliance. Please see the OSH Answers document, OccH&S legislation in Canada, basic responsibilities, for more information. That was the one that we just finished. That was the one we just finished. These general provisions give employers the freedom to carry out measures and control procedures that are appropriate for their individual workplaces. On the other hand, the challenge for the employers is to know when they have fulfilled all appropriate regulatory requirements. More information about this challenge is in the Due Diligence OSH Answers document. That brings this page to the end. Document was last updated on July 8th, 2008. That brings us back to the fourth and final point, which is OH&S legislation in Canada, due diligence, which is the one that they just talked about. And clicking on that link brings you to www.ccohs.ca/OSH answers/LEGISLEGISLence.diligence.html, which brings you to a Government of Canada website on behalf of the Canadian Centre for Occupational Health and Safety, also known as CCoHS. It's an OSH answers fact sheets on OH&S legislation in Canada, due diligence. This is the basis of all law, is due diligence. Due diligence must be exercised or it's not proper. Anyway, what is meant by due diligence? And this is a requirement of every government official, employee, police, the Crown, everybody. The citizens, every citizen. Like I said, it's our shared responsibility for everything, for each other, and making sure that those who claim to be an authority or actually have the authority and not just the power, especially the power to deceive. What is meant by due diligence? Due diligence is the level of judgment, care, prudence, determination, and activity that a person would reasonably be expected to do under particular circumstances. Applied to occupational health and safety, due diligence means that employers shall take all reasonable precautions under the particular circumstances to prevent injuries or accidents in the workplace. This duty also applies to situations that are not addressed elsewhere in the occupational health and safety legislation. Reasonable precautions are also referred to as reasonable care. It refers to the care, caution, or action that a reasonable person is expected to take under similar circumstances. Another term used is employers must do what is, quote, reasonably practicable, end quote. Reasonably practicable has been described by the Labour Program Canada as taking precautions that are not only possible, but that are also suitable or rational given the particular situation. Determining what should be done is usually done on a case-by-case basis. To exercise due diligence, an employer must implement a plan to identify possible workplace hazards and carry out the appropriate corrective action to prevent accidents or injuries arising from these hazards. Excuse me, sorry. Sorry. Why does due diligence have special significance? Due diligence is important as a legal defense for a person charged under occupational health and safety legislation. If charged, a defendant may be found not guilty if he or she can prove that due diligence was exercised. In other words, the defendant must be able to prove that all precautions reasonable under the circumstances were taken to protect the health and safety of workers. Due diligence is demonstrated by your actions before an event occurs, not after. How does an employer establish a due diligence program? The conditions for establishing due diligence include several criteria. The employer must have in place written OH&S policies, practices, and procedures. These policies, etc., would demonstrate and document that the employer carried out workplace safety audits, identified hazardous practices and hazardous conditions, and made necessary changes to correct these conditions and provided employees with information to enable them to work safely. The employer must provide the appropriate training and education to the employees so that they understand and carry out their work according to the established policies, practices, and procedures. The employer must train the supervisors to ensure that they are competent persons as defined in legislation. Ensure that managers and supervisors talk to new employees about safety during orientation training. Meet regularly with staff to discuss health and safety matters. Inspect areas of the workplace under their responsibility and respond promptly to unsafe conditions and activities. Pay attention to routine and non-routine activities, ensuring that employees understand the hazards and the preventative measures to be followed. Excuse me. The employer must monitor the workplace and ensure that employees are following the policies, practices, and procedures. Written documentation of all progressive disciplining for breaches of safety rules is considered due diligence. There are obviously many requirements for the employer, but workers also have responsibilities. They have a duty to take reasonable care to ensure the safety of themselves and their coworkers. This includes following safe work practices and complying with regulations. The employer should have an accident incident investigation and reporting system in place. Employees should be encouraged to report near misses, and these should be investigated also. Incorporating information from these investigations into revised, improved policies, practices, and procedures will also establish the employer is practicing due diligence. Sorry. The employer should document in writing all of the above steps. This documentation will give the employer a history of how the company's occupational health and safety program has progressed over time. Second, it will provide up-to-date documentation that can be used as a defense to charges in case an accident occurs despite an employee's due diligence efforts. Employers must also ensure that all people who are at the workplace are included, such as contractors, visitors, students, interns, and volunteers. All of the elements of a due diligence program must be in effect before any accident or injury occurs. If employers have questions about due diligence, they should seek legal advice for their jurisdiction to ensure that all appropriate due diligence requirements are in place. Remember, due diligence is demonstrated by your actions before an event occurs, not after. More information on how to establish these programs is available through OSH answers, including establishing an OSH program, emergency planning, hazard control, guide to writing an OccH&S policy statement, inspection checklist, and job hazard analysis. Those previous 5 points were links to that information. What documentation is needed to show due diligence? Written documentation is essential. Records, reports, and documentation for the following activities can include worker orientation, education, and training, workplace inspections, including corrective actions taken, accident incident reports, including corrective actions taken, supervisor notes, for example, supervisor inspections, meetings with workers or contractors regarding safety, etc., health and safety committee meeting minutes, equipment logbooks and maintenance records, emergency response drills and exercises, instructions or safe work procedures, including any changes, forms and checklists used when following safe work procedures, for example, confined space entry permits, sampling and monitoring records from exposure testing, statistics about the frequency and severity of injuries, etc., enforcement of health and safety rules and procedures. What are areas to consider when reviewing due diligence? When reviewing your due diligence program, it may help to ask yourself the following questions. 1. Can a reasonable person predict or foresee something going wrong? 2. How severe is the potential harm to workers? 3. Is there an opportunity to prevent the injury or incident? 4. Who is responsible for preventing the accident or incident? Then under what is an example of due diligence checklist, there's a due diligence checklist. There's 3 columns. One is yes, the other one is no, and then under description. So yes or no, do you know and understand your safety and health responsibilities? Do you have definite procedures in place to identify and control hazards? Have you integrated safety into all aspects of your work? Do you set objectives for safety and health just as you do for quality production and sales? Have you committed appropriate resources to safety and health? Have you implemented appropriate control measures for identified hazards? Have you explained safety and health responsibilities to all employees and made sure that they understand it? Have employees been trained to work safely and to use proper protective equipment? Is there a hazard reporting procedure in place that encourages employees to report all unsafe conditions and unsafe practices to their supervisors? Are managers, supervisors, and workers held accountable for safety and health just as they are held accountable for quality? Is safety a factor when acquiring new equipment or changing a process? Are contractors, volunteers, and others in the workplace held to the same safety standards? Do you keep records of your program activities and improvements? Do you address concerns and recommendations made by workers, the Health and Safety Committee or representative, and others? Have items from reports such as inspections or accident incident reports been reviewed and corrective actions taken? Have these steps been documented? Do you keep records of the education and training each employee has received? Do you check to confirm that all policies and procedures are being followed regularly? Do your records show that you take disciplinary action when an employee violates safety procedures? Do you review your OSH program at least once a year and make improvements as needed? That's the end of that checklist. Again, each one of those points was a yes or no question. Document was last updated on January 12, 2015, so that's the most updated page. That takes us to the end of that page. And the last of the 4 links under responsibilities. Again, there are 5 links under the heading of elements of a health and safety program, which consist of basic OccH&S program elements, job hazard analysis, risk assessment, inspection checklist, general information, guide to writing an OSH policy statement. And I'm not going to bother going with that because that's getting off topic. We do encourage other people to go and, again, even the workers, it's good to know this stuff. For further information, so feel free to go to the website and click on those links and follow those links. It's a little too layered for me because I'm trying to keep it focused on Bill C-45 and the changes to the criminal code and what it means to actual enforcement or supposed enforcement. Anyway, for further information, review our Health and Safety Program section of OSH Answers. It says down here, where do I find a copy of the Criminal Code is the next heading. Criminal Code of Canada, there's a link for that, which probably takes you to ELAW's website. And also there's a plain language guide, Bill C-45, Amendments to the Criminal Code Affecting the Criminal Liability of Organizations. That's a link to that as well. I will be including that in this segment or whatever, this grouping of videos. And as I said, this document was last updated on January 16th, 2014, so it's up to date. Again, that is www.ccoh.ca/OSH answers/LEGISL/Bill C45.html, which takes you to the Government of Canada website on behalf of Canadian Centre for Occupational Health and Safety, also known as CCoH. OSH Answers Fact Sheets, which is the website's easy-to-read question-and-answer fact sheets covering a wide range of workplace health and safety topics from hazards to diseases to ergonomics to workplace promotion. And again, there's a link there. This is a lot of information available to both employers and employees. So the information's out there, and there's no excuse. This is part of the due diligence that we were talking about. So that's Bill C-45 overview. What we do is we take it right to the criminal code now, and that takes us to the section which was amended under this Bill C-45. It's identified as, I gotta figure out what this website is first. Okay, so it's located at www.parl.gc.ca/house publications. So the word house with capitalized and the word publications capitalized, but no spaces. /publication.aspx?pub equals bill and doc equals C-45 and language equals E and mode equals 1 and parl equals 37 and SES equals 2 and fill 2 and file equals 16 number 1, number sign 1. Again, all these words as they appear are capitalized at each one. So that's the website. Brings you to the Parliament of Canada website. And it says 5152 Elizabeth 2, Chapter 21. I'm only going to read the parts that apply to, this is obviously during the 51st and 52nd session, I believe. Chapter 21, these are the amendments to the code. This is, so I'll only read the relevant stuff. We're at about an hour now. And then I'm going to break off and we will come back with the Corporate Criminal Liability Guide. Corporate Criminal Liability, a Plain Language Guide, as a separate video, which will then be the next section of this series. So, Chapter 21, an act to amend the Criminal Code, Criminal Liability of Organizations. And in box parentheses below that it says assented to 7th of November 2003, end of box parentheses. Her Majesty, by and with the advice and consent of the Senate and House of Commons of Canada, enacts as follows. Then in sidebar it says R period S period comma C period C hyphen 46. Criminal Code 1 subsection 1. The definition everyone, person, owner in section 2 of the Criminal Code is replaced by the following. Everyone, person and owner and similar expressions include Her Majesty and an organization. Subsection 1 section 2. Section 2 of the Act is amended by adding the following in alphabetical order. Organization means A public body, body corporate, society, company, firm, partnership, trade union or municipality, or B an association of persons that 1. is created for a common purpose, 2. has an operational structure, and 3. holds itself out to the public as an association of persons. Representative in respect of an organization means a director, partner, employee, member, agent, or contractor of the organization. Senior officer means a representative who plays an important role in the establishment of an organization's policies or is responsible for managing an important aspect of the organization's activities, and in the case of a body corporate includes a director, its chief executive officer, and its chief financial officer. The Act is amended by adding the following, number 2. The Act is amended by adding the following after Section 22. 22.1. In respect of an offense that requires the prosecution to prove negligence, an organization is a party to the offense if A. acting within the scope of their authority, 1. one of its representatives is a party to the offense, or 2. two or more of its representatives engage in conduct, whether by act or omission, such that if it had been the conduct of only one representative, that representative would have been a party to the offense, and B. the senior officer who is responsible for the aspect of the organization's activities that is relevant to the offense departs, or the senior officers collectively depart, markedly from the standard of care that in the circumstances could reasonably be expected to prevent a representative of the organization from being a party to the offense. 22.2. In respect of an offense that requires the prosecution to prove fault other than negligence, an organization is a party to the offense if, with the intent, at least in part, to benefit the organization, one of its senior officers, A, acting within the scope of their authority, is a party to the offense. B, having the mental state required to be a party to the offense and acting within the scope of their authority, directs the work of other representatives of the organization so they do the act or make the omission specified in the offense, or C, knowing that a representative of the organization is or is about to be party to the offense, does not take all reasonable measures to stop them from being party to the offense. 3. The Act is amended by adding the following after Section 217. 217.1. Everyone who undertakes or has the authority to direct how another person does work or perform a task is under a legal duty to take reasonable steps to prevent bodily harm to that person or any other person arising from that work or task. 4. Paragraph 328E of the Act is replaced by the following. E. By the representatives of an organization from the organization. Okay, 5 sub 1. The portion of the paragraph 362(1)(c) of the Act before subparagraph 1 is replaced by the following. C. Knowingly makes or causes to be made directly or indirectly a false statement in writing with intent that it should be relied on with respect to the financial condition or means or ability to pay himself or herself or any person or organization that he or she is interested in or that he or she acts for the purpose of procuring in any form whatever, whether for his or her benefit or the benefit of that person or organization. 2. Paragraph 362(1)(d) of the Act is replaced by the following. Knowing that a false statement in writing has been made with respect to the financial condition or means or ability to pay himself or herself or another person or organization that he or she is interested in or that he or she acts for or procures on the faith of that statement, whether for his or her benefit or the benefit of that person or organization, anything mentioned in subparagraph C 1 to 4. 6. Section 391 of the Act is repealed. Okay, so this is, it goes on to, well, let's finish this. 6.1, the portion of subsection 418(2) of the Act before paragraph A is replaced by the following. 2. Everyone who, being a representative of an organization that commits by fraud an offense under subsection 1, comma. 7. Paragraph 462.383(b) of the Act is replaced by the following. B. A warrant for the arrest of the person or a summons in respect of an organization has been issued in relation to that information. And 8. Section 538 of the Act is replaced by the following. 538. Where an accused is an organization, subsections 556(1) and 2 apply with such modifications as the circumstances require. 9. Section 556 of the Act is replaced by the following. 556(1). An accused organization shall appear by counsel or agent. 2. Where an accused organization does not appear pursuant to a summons and service of the summons on the organization is proved, the provincial court judge, or in Nunavut, the judge of the Nunavut Court of Justice, A, may, if the charge is one over which the judge has absolute jurisdiction, proceed with the trial of the charge in the absence of the accused organization, and B, shall, if the charge is not one over which the judge has absolute jurisdiction, hold the preliminary inquiry in accordance with Part 18 in the absence of the accused organization. 3. If an accused organization appears but does not elect when put to an election under subsection 5362 or 5361 sub 2, the provincial court judge or judge of the Nunavut Court of the Justice shall hold a preliminary inquiry in accordance with Part 18. 10. Subsection 575 of the Act is replaced by the following. Number 5. Where an accused other than an organization is convicted, the judge or provincial court judge, as the case may be, shall issue or cause to be issued a warrant of committal in Form 21. Section 528 applies in respect of a warrant of committal issued under this subsection. 11. The heading before Section 620 and Section 620 to 623 of the Act are replaced by the following. Organization. 620. Every organization against which an indictment is filed shall appear and plead by counsel or agent. 621(1). The clerk of the court or the prosecutor may, where an indictment is filed against an organization, cause a notice of the indictment to be served on the organization. 2. A notice of indictment referred to in subsection 1 shall set out the nature and purport of the indictment and advise that unless the organization appears on the date set out in the notice or the date fixed under subsection 548(1) or 2.1, and enters a plea of not guilty will be entered for the accused by the court, and that the trial of the indictment will be proceeded with as though the organization had appeared and pleaded. 622. Where an organization does not appear in accordance with the notice referred to in section 621, the presiding judge may, on proof of servance of the notice, order the clerk of the court to enter a plea of not guilty on behalf of the organization, and the plea has the same force and effect as if the organization had appeared by its counsel or agent and pleaded that plea. 623. Where an organization appears and pleads to an indictment or a plea of not guilty is entered by order of the court under section 622, the court shall proceed with the trial of the indictment, and where the organization is convicted, section 735 applies. 12. Subsection 651 of the Act is replaced by the following. 651. Subject to subsection 1.1 to 2 and section 650.01, an accused other than an organization shall be present in court during the whole of his or her trial. Section 703.2 of the Act is replaced by the following. 703.2, where any summons, notice, or other process is required to be or may be served on an organization and no other method of service is provided, service may be effected by delivery, A, in the case of a municipality, to the mayor, warden, reeve, or other chief officer of the municipality, or to the secretary, treasurer, or clerk of the municipality, and B, in the case of any other organization, to the manager, secretary, or senior officer of the organization or one of its branches. 14. The Act is amended by adding the following after section 718.2, organizations. 718.21, a court that imposes a sentence on an organization shall also take into consideration the following factors. A, any advantage realized by the organization as a result of the offense. B, the degree of planning involved in carrying out the offense and duration and complexity of the offense. Whether the organization has attempted to conceal its assets, C, whether the organization has attempted to conceal its assets or convert them in order to show that it is not able to pay a fine or make restitution. D, the impact that the sentence would have on the economic viability of the organization and the continued employment of its employees. E, the cost to public authorities of the investigation and prosecution of the offense. F, any regulatory penalty imposed on the organization or one of its representatives in respect to the conduct that formed the basis of the evidence, or basis of the offense, G, whether the organization was, or any of its representatives who are involved in the commission of the offense were convicted of a similar offense or sanctioned by a regulatory body for similar conduct. H, any penalty imposed by the organization on a representative for the role in the commission of the offense. I, any restitution that the organization is ordered to make or any amount that the organization is paid to a victim of the offense. And J, any measures that the organization has taken to reduce the likelihood of it committing a subsequent offense. 15. Subsection 721 of the Act is subsection 1, of the Act is replaced by the following. 721 subsection 1. Subject to regulations made under subsection 2, where an accused other than an organization pleads guilty to or is found guilty of an offense, a probation officer shall, if required to do so by a court, prepare and file with the court a report in writing relating to the accused for the purpose of assisting the court in imposing a sentence or in determining whether the accused should be discharged under section 730. 16. Subsection 727 subsection 4 of the Act is replaced with by the following. Subsection 4. If under section 623 the court proceeds with the trial of an organization that has not appeared and pleaded and convicts the organization, the court may, whether or not the organization was notified that a greater punishment would be sought by reason of a previous conviction, make inquiries and hear evidence with respect to previous convictions of the organization, and if any such conviction is proved, may impose a greater punishment by reason of that conviction. 17. Subsection 730 subsection 1 of the Act is replaced by the following. 730 subsection 1, where an accused other than an organization pleads guilty to or is found guilty of an offense other than an offense for which a minimum punishment is prescribed by law, or an offense punishable by imprisonment for 14 years or for life, the court before which the accused appears may, if it considers it to be in the best interest of the accused and not contrary to the public interest, instead of convicting the accused, by order direct that the accused be discharged absolutely or on the conditions prescribed in a probation order under subsection 731 subsection 2. 18 subsection 1. The definition optional conditions in subsection 732.11 of the Act is replaced by the following. Optional conditions means the conditions referred to in subsection 3 or 3.1. Section 732.1 of the Act is amended by adding the following after subsection 3. 3.1. The court may prescribe as additional conditions of a probation order made in respect of an organization that the offender do one or more of the following. A. Make restitution to a person for any loss or damage that they suffered as a result of the offense. B. Establish policies, standards, and procedures to reduce the likelihood of the organization committing a subsequent offense. C. Communicate those policies, standards, and procedures to its representatives. And D. Report to the court on the implementation of those policies, standards, and procedures. That ends the end of that website page, and it doesn't say when it was last updated. So we go on. The next part says E, identify the senior officer who is responsible for compliance with those policy standards and procedures. F, provide in the manner specified by the court the following information to the public, namely 1, the offense of which the organization was convicted, 2, the sentence imposed by the court, and 3, any measures that the organization is taking, including any policy, standard, and procedures established under paragraph B to reduce the likelihood of it committing a subsequent offense, and G, comply with any other reasonable conditions that the court considers desirable to prevent the organization from committing subsequent offenses or to remedy the harm caused by the offense. 3.2. Before making an order under paragraph 3.1b, a court shall consider whether it would be more appropriate for another regulatory body to supervise the development or implementation of the policy, standards, and procedures referred to in that paragraph. 19. The portion of subsection 734, subsection 1 of the Act before paragraph A is replaced by the following. 734.1. Subject to subsection 2, a court that convicts a person other than an organization of an offense may fine the offender by making an order under section 734.1. 20, subsection 1, the portion of subsection 735, subsection 1 of the Act before paragraph A is replaced by the following. 735.1. An organization that is convicted of an offense is liable in lieu of any imprisonment that is prescribed as punishment for that offense to be fined in an amount except where otherwise provided by law. 2. Paragraph 735.1b of the Act is replaced by the following. B. Not exceeding $100,000 where the offense is a summary conviction offense. 3. Subsection 735.2 of the Act is replaced by the following. 2. Section 734.6 applies with any modifications that are required when an organization fails to pay the fine in accordance with the terms of the order. 21. Subsection 800, subsection 3 of the Act is replaced by the following. 3. Where the defendant is an organization, it shall appear by counsel or agent, and if it does not appear, the summary conviction court may, on proof of servants of the summons, proceed ex parte to hold the trial. Under the heading Coordinating Amendment 22, on the later of the coming into force of Section 9 of this Act and Section 34 of the Criminal Law Amendment Act 2001, Section 556 of the Criminal Code is replaced by the following. 556.1. An accused organization shall appear by counsel or agent. 2. Where an accused organization does not appear pursuant to a summons and service of the summons on the organization is proved, the provincial court judge, or in Nunavut, the judge of the Nunavut Court of Justice, A, may, if the charge is one over which the judge has absolute jurisdiction, proceed with the trial of the charge in the absence of the accused organization, and B, shall, if the charge is not one over which the judge has absolute jurisdiction, fix the date for the trial or the date on which the accused organization must appear in the trial court to have that date fixed. 3. If an accused organization appears and a preliminary inquiry is not requested under subsection 536.4, the provincial court judge shall fix the date for the trial or the date on which the organization must appear in the trial court to have that date fixed. 4. If an accused organization appears and a preliminary inquiry is not requested under subsection 536.1.3, the Justice of the Peace or the Judge of the Nunavut Court of Justice shall fix the date for trial or the date on which the organization must appear in the trial court to have that date fixed. Coming into force, order, Section 23. The provisions of this Act, other than Section 22, come into force on a day or days to be fixed by order of the Governor and Council. And that's the end of that. So And 119, again, that was quotes of the amendments to the criminal code. You want to put that alongside those acts of the criminal code, those sections of the criminal code, in order to do a proper comparison. Again, the first next installment will be, it looks like, I don't know how many pages that is, but anyway, it's the Criminal Liability of Organizations, a Plain Language Guide to Bill C-45. It looks like, let's see how many pages we got here. Oh, 10 pages. Okay, yes, that'll be in the next installment, and we'll get that out, okay? So hopefully this finds everybody well and informative. This has been informative for everybody, and not too much of a commentary. Sorry about that, but anyway, hopefully it finds everybody well. Stay safe, and we'll be back with the next installment as soon as I'm able. Okay, this is Chris Bacon, the brain injured guy. Say, let's hope we get it all together. Okay, out.